Cameron Thomas.
Thank you, Chair. Professor Barnes, you mentioned that states prefer to settle these sort of issues out of court. I would put it to you that that's not particularly effective. And I'd like to cite, and I'll read from this so I get it right, that in 1986, Japan was a co-signatory to the International Whaling Commission, but that it continued to harpoon whales in the Southern Ocean before and long since it was designated as a sanctuary, before just withdrawing its signature from the International Convention for the Regulation of Whaling in 2019. So it seems to me that the treaties aren't really worth the paper they're written on if they're not enforced. What does effective enforcement actually look like?
I think, taking a step back here, so international law is largely a consent-based, a consensual-based system of law, so it's rules which states create through their own volition, and that also extends to the dispute settlement process. So states will have to agree to be bound by or opt into dispute settlement procedures. So I think we have to acknowledge that, and the example you've given there is where a state may opt out of or take itself out of a treaty regime where it fears that that will affect its vital interests. That's the nature of international law there. So the first point. The second point is that the existence of dispute settlement mechanisms act as a kind of driver on state practice. So states don't like getting brought before international courts and tribunals. It has reputational damage, it has potential financial consequences, and so on. So the existence of these dispute settlement mechanisms, and in particular the strong ones under the Law of the Sea Convention, can act as a driver for states to comply with their laws or to pursue the resolution of their disputes through alternate means. So I think that second factor is quite important. And then ultimately, whilst I said that there isn't that much international litigation, there is international litigation. We have a body of case law which has been developed by the International Court of Justice, by the International Tribunal for the Law of the Sea, the Permanent Court of Permanent Court of Arbitration, which has contributed to the development and compliance of law there. I think at the moment the UK is involved in litigation with the EU concerning its sand deals. So there are these kind of mechanisms which can and are used, I think, even if they're not frequently used. So I think these agreements are certainly worth more than the paper that they are written on.
So long as the parties to that agreement are at the table. So what sort of pressures... Sorry, you look like you were going to respond.
No, I think that's a fair enough point.